Hi, I'm Jeffrey Wernick and here with Bruce Fein, and welcome to uh, another opportunity for an intellectual feast with Bruce. Uh, this week, Bruce has chosen the book to discuss and review. The book is entitled Injustice: How Politics and Fear Vanquished America's Justice Department. It was written by, I believe, two Washington Post reporters, Carol Leonig and Aaron Davis. So, Bruce, why don't you tell us why you chose this book and what do you think is important for us to discuss about the book that you think?
Yes, I chose the book not so much for the details, but because it raises the very thorny question of the executive branch, the president's obligation to take care that the laws be faithfully executed, uh, and what are the constitutional um, deterrents to unfaithfully executing the law, and what does it mean to faithfully execute the law, since we know we don't have enough resources, to make sure that every single violation of the federal law can be identified and prosecuted. The book was chosen in part because it's timely, given the very strong efforts of the Trump administration to openly and blatantly, corrupt the even-handed administration of the laws by openly and notoriously claiming the laws will be utilized to hammer political opponents and to give out of jail free cards to those who are preferential, which is obviously not what accords with our idea of justice, is that it's colorblind, it's uh, viewpoint blind, and it just focuses on a person's actions, not their opinions. Now, the book itself, it's not all that informative for somebody who knows how the Justice Department works and followed the newspaper stories after January 6th and the prosecutions that followed. This is a very detailed, granular description of the names of people who were involved, what were the restraints, how did the Attorney General react to requests for search warrants, the internal divisions of the department, what crimes should be charged. Should they be charged about Mr. Trump or should be charged about allies? But those, I believe, to me, are less important than focusing on the larger issue of what we call inherent prosecutorial discretion. Um, and it's a very important issue, and I don't want to fault find the authors, but they really don't grapple with the necessity of having some legitimate political input into prosecutorial discretion. And it's not novel with regard to Mr. Trump or even Mr. Biden, President Biden, when he pardoned his son, Hunter Biden, after he said he wouldn't pardon his son, and had his own predilections as to what theories of law to pursue that were different than Mr. Trump's. Let me just give you a couple of examples. Harry Truman, at one point in his presidency, he gave a green light to the so-called Seven Sisters. It was part of his foreign policy in the Middle East. They are the Seven Sisters, very huge behemoth oil companies, and
There's
gave.
Aramco, right?
It now turned into Aramco, but this is pre-Aramco
Yeah.
stage. But these companies, he gave them the authority to fix prices. That they were negotiating with what you might call the statelets in the Persian Gulf over their oil concessions, and it was clear that it was thought this was important. That the price of oil, I mean, it was a glut at that time. They were trying to raise price rather than reduce prices. But he interceded with the Justice Department, said, no, we're not going to pursue criminal price fixing actions. And then we have situations during the Kennedy administration when Robert Kennedy was Attorney General. He had created what basically was a Get Jimmy Hoffa squad. He had a personal enmity that had been ignited while he was serving as counsel in the Senate of the United States. And he, for whatever reasons, hated Jimmy Hoffa, who was then head of the Teamsters Union. He didn't have a very favorable reputation. He then disappeared. We still don't know where he's buried or what the cause of death was. But Bobby Kennedy was out to get him. And I believe that total misuse of the department, ultimately they did get him for tampering with the jury. But this was clearly an effort to utilize Justice Department, to attack a political enemy. It wasn't as though Jimmy Hoffa was a national security threat. And we have situations that I know of personally when I was at the Justice Department, where Richard Nixon, the White House, was interceding with regard to certain mergers concerning IT&T and Hartford Insurance. They wanted to get it okayed by the Justice Department. Remember, IT&T was an ally of the Nixon administration in trying to overthrow the government of Chile, and they were serving as kind of appendages to the CIA. And anyway, I mention this to underscore that President Trump is not the first one, or Mr. Biden, who has tried to wield the discretionary power inherent in law enforcement, to their political advantage. Now, I believe that the framers would have expected that Congress would have impeached and removed any president from so manipulating or abusing law enforcement. But they didn't anticipate, I think, how much Congress has deteriorated. But I want to go back to the fundamentals that I think are raised by the book Injustice. So Article 2, Section 3 of the Constitution obligates the president to take care that the laws be faithfully executed. It's a descendant of the English Bill of Rights, where Parliament announced that a king could not dispense with the laws, couldn't refrain from enforcing the laws. At that time, it was aimed at King James II, who was a Catholic, which was not kosher in England after King Henry VIII separated Anglican Church from Roman Catholicism over marrying Anne Boleyn. But those are details that we don't need to get into. But the fact is that there has to be some discretion in enforcing the laws. I think everybody would recognize that there are some crimes that are more important to be enforced than others. And there has to be some discretion in a prosecutor because they don't have the ability or the resources, to go after everyone for jaywalking or fraud that is $5 or $10. They have to have some discretion. And the challenge is to articulate legitimate reasons for deciding to enforce the law against some, but not all, from the illegitimate reasons. And they are very difficult, but they're very important. I don't know whether there's something that even Congress could write a statute that made it obvious that certain motivations behind the execution of the laws should be forbidden. And that's why I think the impeachment power is the way you police, if you will, the misuse of prosecutorial discretion. And the reason why this is so important, that the prosecutor's function and must be policed, is that you can't imagine a judge, issuing an injunction telling Mr. Trump he should enforce a law against a particular individual. Let's take, for example, the Eric Adams. Remember Eric Adams, for our audience? He was the mayor of New York. He's no longer the mayor. He lost a primary. But he was indicted by the Justice Department. And these were conservatives, even those who had clerked for Antonin Scalia before he passed. And the Trump administration, when it came in, ordered that the indictment be dismissed. Now, there's at least hints that the dismissal was because Eric Adams would encourage and order the city of New York to collaborate with ICE in deportations. And just for background, the U.S. Supreme Court has made clear that a federal government cannot commandeer state or local resources to enforce a federal law. It's permissible, but it can't be required. But it means that states can differ as to whether they wish to cooperate with ICE or not under the Constitution. And Eric Adams was one who was making statements about immigration, making New York City ungovernable, that was tacitly offered in exchange for dismissing the indictment. But we have a system where
Bruce, I'd like to just interrupt on that one point. I
Yeah.
think one of the issues related to the Adams indictment was, the issues of whether you find it with or without prejudice.
Yeah.
That the way they granted that was they kept him on the hook because they could choose to re-indict him any point in time they wanted.
Yes. So
So
we have to fulfill his immigration promise.
that's why people thought there was a quid pro quo,
Yeah.
because if he didn't behave, they had over the head, this is only temporary. We'll watch and observe you. And when the judge made the decision to finally accept it, the judge kind of found it repulsive, but made sure it was done in a way that didn't give the administration any more discretion anymore on whether he could be indicted or not indicted. There would be no ability to indict him in the future for it.
Yes.
So I think that's an important detail. That's all.
Yes. Thank you, Jeffrey. But put yourself in the situation of the judge. Now, it's true under the federal rules of criminal procedure, the judge is supposed to ratify and has to order the dismissal. But there really isn't any option there, because how can you force an administration, a lawyer, to prosecute the case? If you're the judge, are you going to write out the questions and the cross-examination and the argument to the jury? You can't do it. As a practical matter, other than impeachment, it is impossible to compel a administration, a president, a Justice Department to prosecute somebody they don't want to prosecute. There isn't any mechanism other than the impeachment remedy, which says, all right, if you're going to be abusing your prosecutorial discretion in this way, we're removing you from office. And it's kind of like a choice between a nuclear option or nothing at all. So it really has never been exercised in that way. Even when President Nixon was impeached, it wasn't because he interceded to try to enable IT&T to merge with Hartford Life Insurance and not have an injunction sought.
And I have a question for you, Bruce.
Yeah.
Can like the Senate or House Judiciary Committee, when there is an investigation, can they call the Attorney General, someone from the Justice Department, and say, we want to make sure this is not persecution, and we want to hear the case you're building and why you think it's legitimate to use your resources in this type of thing? So is there any interim step before impeachment where the Justice Department, where House or Senate can ask the Justice Department to defend what they're doing, to provide oversight to their actions?
Yes, that's for sure, because if you look at oversight, perhaps the Justice Department is the one that's most urgent to be overseen, precisely because of prosecutorial discretion. And there is no immunity that the Attorney General has from explaining exactly what were the alleged legitimate motives that caused them to prosecute X, but not Y. And if there's sensitive information, Jeffrey, there's something that's been around for 200 and some years. It's called the executive session. Congress could say, well, we don't want to have names that are defamed without an opportunity response. And so we'll hear this testimony under oath in executive session and then decide whether some of it could be released. So this idea that there's only a choice to have this all in the public domain or all secret is just a false choice. And that has been done repeatedly because there is a concern that when you're talking about somebody who's investigated, not indicted, you don't want to have their name tarnished where they haven't had a chance to respond. And that's why you have executive session options. And Congress has not been shown to be leaky, in fact, less leaky than the executive branch is. And that is, I feel, a very, very important component. I think that one of the reasons why, Jeffrey, this has fallen in the desueto, for example, there wasn't any statement in hearings as to why the Eric Adams indictment was dismissed, by the Congress, is because the Congress has been so weak in enforcing their subpoenas. The Attorney General, the President said, we're not going to supply this information, we're not going to supply that information, and they assert these, I believe, unpersuasive claims of executive privilege state secrets. But those claims, even attorney-client privilege, doesn't apply to congressional investigations. And they do have, the trump card, if you will, without making light of it in the inherent contempt power. And this is very, very important to understand about Congress and why they've surrendered so much authority and transparency. And that is in a case called McGrain and Dougherty. This is almost 100 years old. The Supreme Court held that Congress has inherent contempt power that's equivalent to the inherent contempt power of a judge. And that means that Congress can find a member of the executive branch immediately in contempt for not responding to a subpoena or not testifying, and put them in prison or fine them. They don't have to wait and go to court. However, this hasn't been done for over 80 years now. But that's ultimately, in my judgment, what you must do if you're going to be taken seriously as an overseer. Because if you go to court, it takes years and years. And then if you lose, go to court, or you win at the district court level, it goes to the Court of Appeals, they put it on hold. The duration of a congressional subpoena is only 2 years because it expires after each term, 2-year term of Congress. And so it's simply really not an adequate substitute for inherent contempt power. And moreover, the inherent contempt power, Jeffrey, includes the right to appoint even private attorneys to enforce a finding of contempt. In fact, Congress would have authority to appoint its own special prosecutor and prosecute an individual for ignoring a congressional subpoena or demand for testimony. But it hasn't been done for so long, and that's why the oversight ends up being not really a substitute for impeachment and removal.
Yeah, let me ask you another question related to this.
Yeah.
We've seen in the press that several judges have threatened to hold members of the Trump administration in contempt for not cooperating with the courts. I'm referring to the courts now, not Congress. Okay. If the way the Trump administration has behaved with the courts, if that was somebody other, if that was just a private individual who behaved exactly the same way,
they'd be in jail right now.
Would they be the same?
No, they'd be in jail immediately, for sure.
So these judges are not stupid people. They know they're giving privileges to people in the executive branch that an average person who is not part of the executive branch would not also have these same privileges. Likely, is that a fair
statement? For sure. But this is, and this is, I'm not sure that I would call it defense of judges. This is one of the issues that they confront when they're dealing with an executive branch official that they don't confront with a private individual. And that is, let us suppose that the judge finds the president, cabinet member, someone else in contempt, and they appoint a special prosecutor to prosecute the contempt because Trump's not going to prosecute his own people. And then and a jury or the judge finds, yeah, you are in contempt, and orders sentence 30, 60 days detention. That the judge doesn't have access to marshals that can go out and arrest people. So at least one of the fears is that they find someone in the executive branch that's worthy of imprisonment for flouting an order and can't enforce it because Trump says, wait a minute, I'm not going to go. So they worry about forcing, that clearly would be a constitutional crisis at that point.
That seems to me, though, an acknowledgement. I can understand the concern. I strongly disagree with it. I can understand the concern. I think it's cowardice, in the sense of why is it causing a crisis? It's only causing a crisis because one branch decides it wants to ignore two other branches, and the other branches decide. The crisis is the fact that the other two branches have waived their constitutional obligations. So the crisis already exists. The crisis already exists. They have renounced, and abrogated their constitutional responsibility. What the Constitution should say should happen is Congress is watching the president go to court. The Congress is watching the court making a reasonable order of compelling somebody to come to give testimony. the administration is just thumbing its nose in a way that no other person, anyone else would be in jail for. Okay. And then Congress can sit back and say, well, we think the president has violated their constitutional responsibilities because they're not having people show up in a court that is a court that judges everyone, and they think they're the exception to the rule. And we as Congress don't think we got to let them know they are not the exception to the rule. So as you say so frequently, Madison said, the end of government is to do justice, and the end of civil society is to do justice.
Right.
This clearly, as the book said, is injustice. So this is basically the courts acknowledging that the constitutional process already has failed. So I mean, why? So what they're doing is they're accepting the failure. So they're becoming part of the failure of the system. So so the crisis is the fact that they in Congress, are just not responding.
Well, listen, I don't want to dispute anything that you've said, Jeffrey, and I don't. I have your attitude too. I'm trying to explain why
Yes.
there's a difference, okay?
Yes.
Not to argue that that should make a difference. And let's go back a little bit in history,
Okay.
right? And we don't have people of heroic stature, who come upon the scene regularly. Remember Sir Thomas More. Henry VIII said, you got to give me a legal opinion that says I can divorce Catherine of Aragon and marry Anne Boleyn, and say I never was validly married to Catherine of Aragon. And Sir Thomas More said, I can't do that, because it's not true. It's not a justify annulment. So he gets beheaded and his successor gets promoted, okay? So how many, you're asking for us to act like Sir Thomas More or like Tank Man in Tiananmen Square, right?
Yes.
Okay. Good luck finding a whole lot of compatriots. I believe I would want to act that way, but you could understand dealing with ordinary human beings that's not very likely to carry the day. So, and because I agree with you, I would rather have the court say, listen, okay, go ahead, flout it. Now everyone's out there can see either Congress does its job or the republic's over. You decide. I'm willing to go to the barricades if needs to be so, but not everybody, flies to the barricades and willing to defend themselves. And it's a sad commentary, but it's simply true. It's something that Oliver Wendell Holmes remarked. He said, well, what are your rights? And he responded, well, it's what you're willing to fight and die for in the long run. If the other side knows that if they push hard enough, you're going to back down, you don't have any rights. And it's not something that I'd be the last one to encourage. I said, I don't, I think that violence is presumptively wrong, except in self-defense. But after all, at some point, and it's a judgment call based upon brains and wisdom and how much you've tried to alternate avenues of redress. At some point, you've got to say, well, if I got to die, I got to die for a reason and a purpose. And like Socrates, we had to take the hemlock to emancipate the mind. Well, that's what he had to do. He didn't want to do that, but the alternative was worse. It was a disgrace on himself as an individual with character. And we won the Revolutionary War. The Minutemen at Lexington and Concord, they weren't having placards and protesting taxation without representation. They had muskets, right? And they were being attacked with the British soldiers had arms. So that's a conundrum, and I think we may have to confront it in our time, Jeffrey, given the erratic nature of Mr. Trump. And I would hope not. And we should try all peaceful avenues of redress. But at some point, you got to say, you know what, I can't live under these circumstances. I'm not going to be a serf. It's like I tell myself, if I'm on life support and I don't have a brain, take it off. I don't need to stay around forever. And I view being treated like a serf and you can't think for self as being on life support, and I don't want to live that way. But that's what we confront right now. You hit the nail on the head. And the courts can just say, well, this is what the law is. It's like Sir Thomas More, but when they see what happened to Sir Thomas More, even though he wins, pages in the history books, he didn't have a long life after he stood up for himself.
He stood up for himself, and he didn't have a long history. 56 people signed the Declaration of Independence.
Yeah,
They ended up having, well, for those that survived the
yeah,
Revolutionary War, they had a long history. That the reason why we enjoy what we enjoy today, for the people who did take that risk.
yeah,
So if they didn't take that risk, what would be our life today? So as you're right, everyone has to determine what they're prepared to fight for. And I was not aware of this your quote from Oliver Wendell Holmes,
yeah,
but I think it's I think it's a wise insight.
yeah,
Okay, that we have a document. This piece of paper says we have inalienable rights, but ultimately, and Jefferson talked about this as well. Is the fact is, if the government tries to take them away, the only thing that'll have us preserve these rights are us continuing to fight for that. And I think Ronald Reagan also reminded us that freedom is very fragile.
yeah.
So, and we have to be vigilant to keep it, and we're just not very vigilant. So,
And that Jeffrey is enshrined right in the Department of Justice building. Yeah, eternal vigilance is the price of justice. And if you're not going to defend your rights and be vigilant, they're going to be taken away. It's this saying that even if you don't want to get in politics, politics wants to get involved with you, use you in a way that you may not like. So it's just the price of self governance. You want to live under despotism, then you don't have to think and worry. But then I think that's living in a crouched situation that is unworthy of human beings. And I'd never want to do that.
are you aware of the work that was done by these two? I think from Yale, I think law professors. I don't know if both were the co-authors. Both of them were law professors, but what they had suggested, and I think they wrote a journal article about this, that in order to avoid the claim that these when one party investigates another party from the executive level, that they had said that actually they should their suggestion is that there should be a grand jury before the grand jury and what they suggested was to get um, a um, a group of former federal judges, half of them appointed by Democrats, half appointed by Republicans, all those that served in a federal court and were now retired. And basically, the attorney general would have to bring their case to this panel of judges, and the panel judges would, to avoid the claim that this is, a political persecution, that they would have to convince these panel of judges that there's merit in the case and that it could be brought to a grand jury, and that way the claim that it's a partisan attack, could be muted. Many people will still say, the panel's not correct, even though these Republicans, they were rhinos or whatever. So I don't think it'll completely solve the problem, but it might mitigate the problem of these types of accusations. And when they did it when they used the documents case, and more than 2/3, so a majority of both judges appointed by Democrats and Republicans, a majority of both of them believed that again they were not determining guilt or innocence. They were just saying based upon everything that was made public to them, and they didn't even have all the stuff that Eileen Cannon or whatever had available because we haven't seen that, but just based upon what was publicly available. So they didn't see Jack Smith's full case, but what they did see that was in the public domain, they all thought was an indictable case. They thought that was a case that should go to trial.
Mm-hmm.
So overwhelmingly. So what do you think about ideas like that? If basically the Justice Department said, okay, we don't need to hire special prosecutors. This is a way we can avoid any sort of considering people abuses. That if we got this star chamber together of you knew who the judges' names are, they were appointed either by Clinton or Obama or Reagan, or Bush. So you know what their track record and history is about, how they've opined on cases, and so hopefully it should have some credibility that this is not the decision made by a Pam Bondi or a Barr. or Garland, that they consulted, this quote Star Chamber, that on the most part people would think, okay, these are reasonably minded people, and if they think this is indictable, then probably it's indictable.
Yeah.
What do you
Well,
think of that idea?
there's a problem. It doesn't mean it's not maybe the best solution, but first we run into the appointments clause, where any person exercising significant authority under the United States has to be nominated by the president, confirmed by the Senate. So I don't see how you can have these persons. They're exercising how you described it. They're stepping into the shoes of the attorney general, right? And they're being a check. They're exercising the same kind of prosecutorial decision that an attorney general would make or a deputy. And I don't see how they would be constitutional without under the appointments clause, without having Senate confirmation.
So they'd have the same problem that allegedly Jack Smith, that Eileen Cannon disqualified John Smith. I guess only to the extent that they use it as an advisory board, and ultimately the attorney general still made the decision, and ultimately they had no ability to compel anything other than they were giving an opinion, and that's an opinion that attorney general can say, look, I brought these people together, I presented to them first. This is what they said, but I'm not bound to follow their judgment. I'm just telling you this is the effort I did prior to bringing it to a grand jury, and maybe that might be compelling enough. I don't know. I'm just
Maybe. I mean, the attorney general can do that already. He can talk to whoever he wants in making these decisions. Then we have there's a Federal Advisory Committee Act that basically is what you've described here would be an advisory committee. They have to be in the sunshine. I think I think it's useful because it spots a problem, but I don't know whether it's not a cure worse than the disease. In the sense that number one, even when you have the universe of retired judges, I can guarantee you, having myself participated in judicial selection up to the Supreme Court, there's huge politics involved in judicial selection. Nobody gets. That's why Learned Hand never got to the U.S. Supreme Court, although perhaps he was the most qualified of all. So they come with a political angle already, and if they've sat, and they're going to have huge track record because they'll have sat on all these cases, and so it's likely that they'll be criticized. Well, you've shown yourself more likely or less likely to support X, Y, Z. And I don't know whether we want somebody to say have this power. They're not accountable. They haven't been elected. They haven't been appointed to this position. They have been confirmed by the Senate. So I'm not convinced that's a remedy that's, number one, constitutional, or two, if you make it constitutional, it really adds anything.
okay.
The circle of people that Attorney General consult already. And I also believe that the superior remedy, if it would be utilized, is, as you pointed out, Jeffrey, oversight and impeachment. This is, hey, you're there. You have to face up to this. What's the reason for X, Y, Z? And if it's clear that it's partisan, illegitimate reason, then, you impeach and we'll find somebody else. Again, I sound a little bit like a broken record because I think that all of these fundamental deformities in our system at present, they trace back to the pusillanimity. It's to the dereliction of duty by Congress. If Congress did its duty, because once they impeached and removed somebody once, they wouldn't have to do it again. It'd create a huge deterrent effect. But the fact that Congress has abdicated its responsibilities, it pushes the system into distortions to try to correct for that vacancy, if you will, in the constitutional separation of powers.
Yeah, I agree. Once you establish a soft budget constraint, that basically you find any constraint disappears.
Yeah.
So by not impeaching, that's the equivalent of having no budget constraint. In the absence of that,
Yeah.
you get abusive behavior. So, and what brings people back to non-abusive behavior is the acknowledgement that there is a hard budget constraint, and it's not hard, and it's credibly hard. That it will not be violated. And once people get that signal, their incentives change.
Mhm.
So that's the point you're making, that if Congress said, you know, we've been lax in the past, we've been derelict in our duties, but we think the country, the Constitution has suffered because of this. So this year, in celebrating the 250th anniversary of the Declaration of Independence, is the time we got time to reflect on how we've been derelict in our duties and say, we're going to honor, this 250th anniversary by saying we're no longer going to be derelict, and hopefully we'll leave a legacy for the people to remember what the Constitution really was intended to do, why we were founded, that we have to do justice. We lost our way and we're bringing us back. And that if they did that and people believed it, well, we'd have to see for how long the hard budget constraint was preserved, but at least it would immediately change the incentives of, of this president and every other president, that followed. And that's the goal. The goal is not to punish
Yeah.
any one president. The goal is basically to get any president who occupies the White House to understand there's a limits, that there's three branches of government, not one.
Yes, exactly. This is not personalities. And again, we're writing and we're setting these precedents not only for ourselves, but for those yet to be born, for posterity. We want to develop these institutions and expectations, not just for us, but so our children and our grandchildren can inherit a system where they can march to their own drummer. They get the thrill of being captain of their fate. And that's what's wonderful about the United States. And I can never believe why anyone gets thrilled. You look at the map, oh, we get Greenland, we have more territory, whatever. Then that's drivel. No, that's child's play. Like I want a bigger piece of cake, or I want a bigger bed or something like that. What matters is the moral foundations, the philosophical foundations by which we live, and we honor and respect other people. We give them a helping hand if they need it. We want everybody to be a winner. That's the greatness. And I can guarantee you, when you have that kind of philosophy and culture, all the best human beings in the world will flock and want to live under that regime. And that human capital will make you superior to anyone else, even without lifting a gun. Because when it comes to actually fighting in self-defense, people will learn very fast. They love and cherish their freedom. And that's why the Minutemen could defeat the British mercenaries, because they understood what they were fighting for. But they didn't need to have standing armies and things like that. They'll turn into soldiers overnight if it's for a good cause. And that's why it's important that we don't look at the current situation as just a Trump phenomenon. It's not. It's something that is accreted over many, many, many decades. Trump's taken it to a new level. But if we don't take the power back from the White House, his successor will do the same thing. Maybe use different language, but it's not going to cure the problem. That's what we have, and we keep coming back, Jeffrey. We have to have a culture that ostracizes people who don't discharge their citizen responsibilities. We don't send them to jail, but we need to tell them, hey, this is not right. We have to hang together. We hang separately. You just don't have the right to opt out. Otherwise, we're not going to have self-government. Simple as that. You may want to opt out. That's not a choice if you want self-government. You got to have some skin in the game and take some risks. Not necessarily the risks of the signatories of the Declaration of Independence, but something.
Yeah. I'd like to emphasize the point you said, because I don't like that people will get the wrong impression when we have these conversations. Trump is the consequence of Congress being derelict for a long period of time.
Yeah.
So, so when so if it wasn't Trump, it was going to be somebody else.
Yeah.
So it's not the fact that we're blaming the individual. We're blaming the incentives, and the incentives would produce people of this type of behavior. So whether it was Trump or somebody else, what it has been is, to the extent that somebody gets to the White House and sees they can take more power away from the other branches, given the type of personality of somebody who wants to be president, they'll take whatever they can get, and you keep giving more and more, and they keep taking more and more, and then they keep checking the boundaries. And some people, maybe some personalities, are more willing to probe more boundaries than others, but ultimately, if it wasn't Trump today, it would be somebody else who would then probe the boundaries more tomorrow. So I got to remind people, this is not a personal thing against Trump. And we think the reason why somebody like Trump exists is because the Congress has been flawed for a very long period of time. And, Trump is trying to do, on the most part, what other presidents have done, only he's trying to be, only he's better at it. So,
Yeah,
uh,
yeah, yeah, yeah.
so
He's better at it, and also, I think that it's not only Congress derelict, but I also believe the officials in the executive branch are derelict. I mean, I when I was in the government, the Justice Department, FCC, I always understood, Jeffrey, my loyalty and my oath was to the Constitution, not to the occupant of the office. That is my loyalty is to the Constitution. And even you have people during Watergate like John Dean. He talked about the cancer on the presidency. He just couldn't do it anymore. He had flaws to be sure, but he understood that this was just wrong. The cover up, the manipulation of agencies with enemies lists and things like that, and he ultimately pled guilty, served time. But at least he recognized, and the culture was there, that he came forth and said, "I can't do this anymore." I can't participate in this conspiracy. You don't even have John Deans anymore, in this government. People are complying with orders that are flagrantly illegal, openly and notoriously illegal. I mean, let's just think of the examples that are ongoing with regard to the military's killing. I call them murdering alleged drug traffickers in the Caribbean or the Eastern Pacific. Yeah, there's no trial. What is it? And even assuming that they were drug traffickers, you don't have the right to kill them. They have right to trial, and drug trafficking typically isn't even a capital offense. Where's the military saying, I'm obliged to disobey a clearly illegal order? These are, I remember in my lifetime, you may recall too, Jeffrey, Lieutenant William Calley, where his defense was about shooting all the women, children in the ditch in Vietnam was following orders. They said, no, that's following orders in no way. That cannot be a legal order that you shoot men and women in a ditch by the hundreds. But where's anybody standing up and saying, I can't do this? You're ordering me to commit a war crime. I'm not going to do it. So that shows, I think, the importance of a culture that also creates a headwind for violating the Constitution and laws of the United States. And unfortunately, our civic education doesn't teach that. It doesn't teach, the heroism of individuals who have at least some scruples that are not going to do it if that's the wrong thing. But that's what's so conspicuous about the second Trump term. Even in the first term, when it came to the 2020 election, he still had high officials. Even the Attorney General, William Barr, went over and said, there isn't any evidence, that there's any fraudulent voting here. Christopher Krebs, who was the person that Trump appointed to review cybersecurity, said this is the safest election ever. And they said, we're not, you're deluding yourself. And there are others who push back on, creating a false image of voting irregularities that didn't exist, including that one infamous December meeting in the White House after the November balloting, where Mr. Trump was told, if you replace the Attorney General, everybody's going to quit and you're going to have a Saturday Night Massacre. And Trump backed down at that point. But that was because at least you did have some people standing up. But in the second term, there's nothing that we see in terms of asking any questions. There's no adult in the living room. And Trump does, the craziest things in the world. And I'm surprised as well that after these are shown not to be isolated, but to be systemic in the second Trump presidency, that no one, not one, stood up and said, I'm leaving. I can't do this anymore. No Sir Thomas More, not even a dissent from that level. Now, you do have at the lower levels, I would admit, out at the Southern District of New York, the acting U.S. attorney, there have been resignations, but it's got to be, but none out of the cabinet, that the real policymaking officials who are executing these dastardly orders of President Trump. And I don't think that he can escape even the responsibility from Minneapolis. He's the one who appointed Christy Nome. He's not the one who's fired her because of what I consider the video evidence of murders of U.S. citizens, known to be citizens, not in self-defense, but these were harmless and they were shot probably first-degree murder. And then he orders, and the Attorney General has a cover-up, prevents the FBI from coordinating with Minnesota officials to investigate the crimes for possible prosecution. So tries to give them a green light for things of this sort. And it shows that, say the system breaks down without at least some element of good people and institutions playing their role.
Yeah, I am a little surprised at some of the people that like I don't know Scott Bessent, but his pedigree in the sense of where he's worked, the people he's worked with. You know, I generally assume I got to assume like when he gets on the talk shows and says, the guy carried a gun, so it's sad he's dead, but he kind of deserved it and he was asking for it. So, which is that's basically what they're saying. It's that they're justifying the killing because nobody who's really a peaceful person goes and carries around the gun. He was asking for trouble and he got the trouble he asked for. It's bad that he's dead, but he asked for it. That's more or less what they're saying. So I can't believe he really believes that. I mean, I don't.
No, Jeffrey, let me interject. We know he doesn't believe that, and Trump doesn't, because at the same time that you accurately reported what he's saying, the Trump administration is telling the U.S. Supreme Court, defending the right to keep and bear arms, as long as you're not brandishing it to threaten somebody else. So they're promoting and celebrating, the Second Amendment right to keep and bear arms for their political purposes in the Supreme Court, speaking at one side of their mouth. And then out in Minneapolis, where they generate this xenophobia antagonism towards anyone with an immigration, says no. If it's in the process of and connected to immigration enforcement, if you have and you're exercising your right to keep and bear arms, we're going to kill you because we think that the xenophobes won't care, since we were killing you because we were trying to deport not really criminals. These are people who overwhelmingly have committed no crime, but persons who don't look white, they look Asian, they look Latino, they look black, and so they're subhuman people. I mean, it's really that raw, I believe. So it's clear they don't even believe what they're saying because they say the opposite when it suits their convenience.
So my point is the sense that they're selling their self-respect. I mean, if this was somebody I know who behaved like something like that, I'd say, why should I respect you? You don't even respect yourself. How could you respect yourself? By going out, seeing an act that if you and I were private and you were not in the government, you would describe it, you would use very different terms. Yet now you've decided to not say anything you believe, and you're defending something you don't believe, and you're doing it in front of the public and with a huge audience, and you're ridiculing people who believe what you actually believe. What kind of person does that make you? I mean, it's different than the person who actually believes it. But when you know the person doesn't believe it, and they're still willing to represent a lie as either a liar or as a bullshitter, one of the two. And I don't know which one Scott is, if he's a liar or a bullshitter. I think he's more of the liar than a bullshitter. So Trump, I think, is the bullshitter. I don't think Trump cares about the truth at all. I would not make that accusation so far about Bessent. I just think that he's accepted that he would lie on this issue, when he knows the truth, as opposed to Trump, who never cares about whatever it's the truth at all. He just cares about what suits him.
But I think Jeffrey,
you have no self-respect to lie to the American people. What kind of self-respect can you have? And why would we ever want people who have no sense of self-respect? How can you respect somebody who doesn't respect themselves?
Yeah. But I think, Jeffrey, that you've come upon a very important point about how politics attracts personalities who suffer from the defect that you've just described. Let's just do a couple of what about Miss Machado in Venezuela, right? She openly prostitutes herself and says to Mr. Trump, "Hey, you can have my Nobel Peace Prize." Really? And it's obvious that she's catering to him and hoping that maybe he'll throw some support behind her so she can return to Venezuela. I mean, that's character defect. And take the vice president, J.D. Vance. You know, only short months before he accepted the vice presidential nomination, he was characterizing Donald Trump as an Adolf Hitler. Does J.D. Vance actually believe that the leopard changed its spots overnight? No. It shows you how people who get infected with this ambition for political power will do anything, prostitute themselves, make themselves look ridiculous just to rub shoulders with power, which means they're very shallow people. They do not have philosophical anchors. They don't believe anything other than, hey, I want to rise on the power charts. And that's exactly why you need checks and balances. Exactly why you have to make certain that no politician especially exercises unchecked power, because it attracts these kinds of people. I don't applaud it, but I think it's generally inevitable. For every one George Washington, you get 5 million, Napoleons, Putins, Stalins, Donald Trumps, and others. And that's why the system was created, if it functioned properly, to not give anyone this kind of, especially a politician, this limitless power. And it's broken down because Congress has just abdicated its responsibilities.
So now, as we consider, the concept of the the unitary executive,
Yeah.
Knowing that probably, again, because members of the Supreme Courts they're not dumb people, so they observe this, they understand this. So if they make decisions that keep on preventing Congress from creating independent agencies, because they create the agency, then they're not ceding all the governance of that agency over to the executive, but they're saying we're partners in the governance of this agency, and we've created it in a way so that we are partners in this. And once people are approved for the agencies, they can only be removed for cause. And we've designed it that way. We've not designed the agency for you to have absolute, unreviewable, uncontested authority over these agencies. And if you recognize human nature, how could the Supreme and really, I think, was responding to, I don't think there's any precedent in the founders that that they contemplated that we'd have a federal government that spends $7 trillion, and regulates the entire economy and has this type of power, and that they wanted to give the executive branch sole control over all of this stuff, because these agencies really didn't exist when they were there, and government didn't spend so much money, and the executive didn't have any, and we didn't have a standing army. So if we look at the context of what powers the executive has today as opposed to what the executive had back then, I don't know how anyone think that they would not want to have reinforced, a system of checks and balances, that to the extent that government evolved to grow, that basically you had to grow in a way where we kind of tried to preserve, a balance of power. And by changing this, it's not preserving the balance of power. It's transferring a lot of power away from Article 1 power to Article 2 power. So
yeah. Well, I think this, Jeffrey, you've come upon again a very, very wonderful point. And it takes us back to a couple of things. One, the independent agencies began to flower during the presidency of Franklin Delano Roosevelt, where Congress was, giving all sorts of power away, the National Recovery Act, and did the bank holidays, and going off the gold standard, and anyway, and limitless discretion. And so they were there in part because Congress was worried, and this is a time we have dictatorships in Italy with Mussolini, and we have the rise of Hitler, and we got Stalin, and we have Franco and the Spanish Civil War. And so this was an effort to check, a Democrat president, and if you will, who was thought to have much, much too much power. He was the one who in 36, 37 unfolded his plan to pack the Supreme Court as well. So it's kind of ironic that the independent agencies, which were there to check Democrat presidents' limitless power, now are being castigated by the Republicans. But the more important point, Jeffrey, is go back to James Madison. He's a very reliable figure since he was present at the creation. And when he was explaining separation of powers, he is explaining that doesn't mean it's an absolute hermetic seal between the three branches. And let me give you an example right now. The appointment power is viewed as an executive power, right? The appointments clause. But first of all, we have federal judges appointed independent counsels. That's how we got Ken Starr. They were judges appointed Ken Starr, not the attorney general. And that wasn't viewed as a violation of separation of powers. As we speak today, the judges appoint interim U.S. attorneys. If a first U.S. attorney who's appointed as interim by the executive branch isn't confirmed within 120 days. So we have judges now appointing U.S. attorneys. They're exercising the appointment power. No one's suggesting, oh my God, it's unconstitutional, it's a unitary executive. And hey, because the ultimate goal, we go back to Madison, the goal is to secure justice. And if justice means you kind of combine one branch's power with another, then you do it. So you don't miss the forest for the trees. And the independent agencies, if they contribute to the goal of justice by having checks on political partisanship, then they should be constitutional. Anything that enhances and fortifies justice can't be unconstitutional, because that's the reason why we have a system at all. And this is what's been lost. So Madison didn't believe, and Madison acknowledges, I think it's Federalist 36. No, there's going to be some points in blending powers one to another. That's going to be hard to draw the line. It says, well, but you can't have one branch exercising controlling authority over another branch. And this is the appointment power is only one example. Even if you examine the way in which we make laws, there's a blending, right? We have the Congress, they have two branches or chambers of Congress have to pass a law, but the president can veto it. So the president is involved in lawmaking, because if he vetoes the law, it doesn't become law unless Congress goes back and overrules it by 2/3 majorities. And even then, the U.S. Supreme Court to say it's unconstitutional. So you have all three branches involved in some way in lawmaking. But the goal is justice. It's doing this way, we believe we're going to have a more just system of laws than otherwise. So this very simplistic anti-Madisonian idea that no, unitary executive means everything that is arguably falls into the executive domain must be to the president alone with his absolute, without any checks, is absurd. It's anti-Madisonian. It doesn't understand that the goal is justice here, not to give the president infinite power. And that's what makes this idea of a unitary executive so completely constitutionally flawed and ridiculous.
And you served in the FCC, correct?
Yes, I was general counsel of the Federal
Communications. Okay, so if the current head of the FCC came to you and said, you know, these nighttime hosts, they got to spend half their jokes attacking Democrats as opposed to Republicans, don't you think that's what the Constitution intended?
Yeah.
The law is. You know, as the general counsel, what would you tell?
No, say no. That's First Amendment protected activity. Hands off. Hands off. And of course, one of the other ridiculous things is that if you look at the FCC's authority, all these limitations on speech, they're for over-the-air broadcasters. The FCC doesn't really have you just send it the signal by satellite or cable, or whatever. You know, this FCC doesn't have the same authority. The argument is that the airwaves are public property, so we can censor the airwaves, but not cable casters or satellite transmissions. So it applies in only a limited extent in any event, but that it's completely, I think, wrong-headed to use the FCC. And it used to be, you know, internally there was this, I think, understanding that the FCC should not be used in a political fashion. You may recall when President Nixon was threatening the Washington Post when they had Woodward and Bernstein and Watergate, well, we're not going to renew your licenses, and Katharine Graham is going to have real problems. That was knocked out in a second. So no, you can't violate those norms. But now there aren't any norms anymore when it comes to the executive branch. You do whatever you want. And there's very little pushback. But the private sector, there's some. But even then, I think it's a problem. The government's so big when you get companies like ABC and CBS clearly capitulating to Trump's demands on these frivolous lawsuits, says here's 15 million, 20 million. Because why? He says, well, they need to approve a merger because we're going to have our broadcast company merge with somebody else, or they need to approve and they have to get some other regulatory approval. They want to get the good graces of the president. He'll sit down and interview them. So they sell their soul for a mess of pottage. And the system can't operate with that kind of pusillanimity. It just can't.
Now, I got to assume if I got to assume that when making these types of payments that are material in nature, these companies make, maybe or maybe not, they consult their general counsel and their board members. So I mean, I don't think any of them went into their board members or council and said we got a losing case and we got to, just paying $15 million is, we should be really happy because if this goes to court, we're definitely going to lose, and we're gonna end up paying a lot more. I don't think that was so. If you could ever get the minutes of the conversation in the boardroom, do you think that they? I don't think anyone would say they had a losing case. I think they would say what you just said is, the cheapest thing we need to do is pay this guy off, because he could stop because of the problem he could cause for our business.
Yeah.
Mergers we need to get done, other stuff. Let's just pay him off. And it's clear. I don't know really who doesn't believe it's extortion.
Yeah, it is. But it's not just them. I mean, take NVIDIA. I mean, they were clearly extorted. Trump said, I'll permit you. Remember, the Constitution says there can't be any export taxes.
Right.
Clearly, Trump says to them, yeah, you got to give me 25% of your revenue if you sell these semiconductors to China. I mean, that is about as flagrant extortion as you can get. And there's no pushback, nothing. I mean, it's just, my mind boggles because every day I get up and read the newspapers or I'm already read about it, another flagrant constitutional violation. Let me give another one, okay? We have Marco Rubio says, okay, the United States is going to run, the operate Venezuela. We'll submit the budget. I said, wait a minute, you can't spend any money that's not appropriated by Congress. It's very simple. Article 1, Section 9, Clause 7. There's only money the executive can spend. It's got to come through the appropriations process. And now you're going to sell Venezuelan oil, and you're going to run off the shelf. You're going to be running Venezuela, and Congress hasn't appropriated any of this money whatsoever. I mean, it's shocking. And I mean, if I was in Congress, I'd be screaming, says, Mr. Rubio, you retract that. If you cannot operate in Venezuela unless we've appropriated the money for that purpose. If otherwise, we're going to impeach and remove you from office. Then nothing. Silence. I'm speechless that the breadth or the epidemic of constitutional illiteracy and cowardice is so pervasive.
Yes, it's really sad. Do you mind if I ask you just to go back before we conclude today, a few questions on the book itself?
Wonderful. Sure.
Yeah. What was your impression after reading? There's been a lot of accusations about Garland, and this was all politicized, all this stuff, and it was election interference and all the other claims. With the reporting done by the authors here, regarding, and some people trying to understand that Garland was maybe indecisive. He took so long. Was your impression, again, this is just an impression, that Garland was driven by politics and election interference, or did he seem somebody who was very careful to avoid that appearance and tried to be, and maybe was slow because he was concerned about these issues of more interested in doing justice than persecuting a political opponent, but who understood the optics of all of this? What was your impression?
My impression, is that I think the Attorney General, I think Merrick Garland, I think he was too cautious. Obviously, there's a balance here. We don't want to run at supersonic speed. But I think when you're looking at the magnitude of the crimes, which was really perhaps the most serious crime in the history of the United States, worse than the Rosenbergs, at least Julius, selling atomic secrets to the Soviet Union. This is to destroy the country. January 6th was an effort to destroy everything we had accomplished since July 4th, 1776. We are back to power in the executive worse than King George III. That means it should be the highest priority that gets the highest attention. And if there was a calculation, again, it goes to prosecutorial discretion, where I think Garland stumbled. And I want to use the word stumble because I very seldom want to impute bad motives. I don't like to do that. But I think that instead of going after and having huge resources towards all of the 1,500 and more who were at the Capitol and were known by video and otherwise to be involved in some level of criminality, is far more important to go after the top, because that's where it came from. And the resources, well, it's like the bottom and how you prosecute organized crime cases. You start at the bottom and maybe you get some people who flip and then tell the top. But here, where the evidence, in my judgment, was in plain view, that what Trump said on January 6th, including telling Mike Pence, the vice president, choose between me and the Constitution, don't discharge your duties. I think that his mistake was not saying, all right, these other ones, we'll push them off, would use my discretion. The ones who just trespassed didn't use violence. But the resources have got to go to the very, very top, which is Trump and his inner circle, if you will, although it was mostly just Mr. Trump. But it's a judgment call, and I understand that the politics of the time. But that's my critique of Merrick Garland. Too slow, and he should have focused on the larger issue. And I do not believe, Jeffrey, that he displayed, in my view, the typical, I think, very hyper cautious or narrow view of life as judges often do. And well, it is true that the charges against Mr. Trump were novel, but of course they were. January 6th was novel. Don't get frightened. The judicial and even the legal mind, well, it's never been done before. So what? Maybe it needs to be done at this time. It's never been done before. So it creates a caution that is vastly excessive given, the importance and the challenge. I go back. January 6th was an attempt to undo July 4th, 1776. How can you not understand that?
And do you think that maybe also, after reading the book, that there's been one area that's probably been underreported and underdiscussed is the efforts associated with the fake electors and how organized that effort was?
Yeah, this was not spontaneous combustion that cropped up in the individual states. It was organized at the very top, with regard to Mr. Trump. And then John Eastman, his lawyer, who was sort of the brainchild about how this is going to be done. And then the pattern was not identical, but very, very similar. And again, fake electors? You got to be kidding me. That clearly should be the highest priority of all. We still have some of these fake elector issues lingering in a couple of states. But that's where I believe that Merrick Garland did not appreciate that they were going at the jugular of the American Republic. And he did not respond with that same element, I believe, of urgency that he should have.
Yeah, and it seems to me, I think for circumstances that we had that were unprecedented in history,
Yeah.
I think the people deserved a trial. And why do I think that the people deserved the trial? I think people deserve to know the truth. And so I think that all the claims that people were making, outside the court of law, not subject to, charges of perjury, I think the public was entitled to see how people would actually testify, under oath, and find there would be a divergence between what they've said in public and what they said under oath. And I think we already have one strong example of that, and that's, probably more than one, but that's Rudy Giuliani and the things that he said in public and the things that he did not repeat, under oath. Is that a fair statement, Bruce?
Yes, I mean there was one case where he would make public statements. We went into court, I think this in the U.S. Court of Appeals for the Third Circuit, said, we have no evidence of fraud. Because he was talking about federal judges and he would be risking his bar license. We have no evidence of fraud. Even where every other second he was claiming it was massive, massive. We have the theory, now we just need the facts. I mean, in Rudy Giuliani, I did work with him for a while at the Justice Department before he became U.S. Attorney in Manhattan. And he's no dummy, so he knows what he's doing there. And again, it shows that these political ambitions commonly subordinate all other ethical restraints and result in very, very great dangers, to self-governance and the rule of law.
Yeah. And I also think there's if you sit back and say, I'm the president, I'm head of the Justice Department, the end of government and the end of civil society is justice, to the extent that Trump paid a lot of people to find fraud, and the people who he paid actually found evidence exculpatory to the fact that there was an absence of fraud. Normally in a court, if he ever had to testify, that would be discoverable, that people went to him and said, because that goes to the question of what did he really believe and what did he know, as opposed to what he decided just to convince himself of, or just he didn't feel bounded by the truth at all. So whatever he just discarded, not that he didn't believe it, it just was irrelevant to him, which is different. Is you're not telling me what I want to hear, so I'm going to pretend like I never heard it, as opposed to challenging whether it was truthful or not truthful, because I don't care whether it's truthful. So, which is different than you saying you actually believed it. So,
Trump spent millions of dollars after the election in 2020, hiring his own independent investigators to determine whether there was any fraud that affected the election. And when they came back and said no, he just kind of buried it. He said, I don't want that information. Again, he wasn't after the truth. And these people had loyalty to him. They had no reason to fabricate, a conclusion. His own Attorney General, William Barr, who Mr. Trump appointed, said, this is all BS. There isn't any election fraud of any sort that's going to change the outcome of the election. But he didn't really care what the truth was one way or the other. He just wanted to stay in power. So he was ready to manipulate things. And I think maybe Merrick Garland was a little naive in not really understanding the phenomenon of Trump, because he was atypical. In his early years, he was a Democrat, supported Hillary Clinton. He was pro-choice, and then he flipped just because his narcissism forced him to do and say things that kept him in the center of the public limelight forever. And that's a very dangerous person who will do anything at that point to just draw attention to himself, no matter how illegal, unethical, or otherwise.
And with respect to Barr, as is my recollection, and you'll probably, and I'm sure you'll know better than me, that when it came to, Barr came in to defend Trump. He came into the administration. He pretty much aborted the Mueller investigation when it was still ongoing, and basically told Mueller he needed to stop. And while it continues to be underreported, is that while Mueller absolved Trump of, colluding with Russia, they still thought there seemed to be a case that they were investigating regarding him obstructing justice, and that Mueller contested the Barr's characterization of the Mueller report, specifically with respect to, that's my recollection, to the obstruction of justice charges, and that it seemed to be that while they were not ready to make a final determination, they thought there was a good case for obstruction of justice charges against Trump. Is that a fair statement I'm making, or?
Yes, it is. And having myself been involved in Watergate, when you look at the Article 2 impeachment voted against Mr. Nixon, it was one of the pieces of evidence against Mr. Nixon for obstructing justice was, firing or attempting to fire Archibald Cox, the special prosecutor. Well, the evidence was overwhelming. Trump was raising that with his general counsel all the time. Hey, we got to get rid of him. We got to get rid of him. Who's going to fire him? We got to get rid of the attorney general so we can have somebody else come in and make different decision on appointing a special prosecutor. So the evidence was virtually the same between Mr. Trump's efforts to squash the special prosecutor and Mr. Nixon's. Because the difference was Mr. Nixon left office and nothing happened to Mr. Trump.
Because I'm making this point only in the context of the fact that what do we have about Barr's behavior?
Yeah.
We had Barr came in to kill the Mueller report. He did. Then he appointed Durham, and he went around with Durham to investigate some of the claims, and he personally involved himself in that. Until they didn't find anything.
Yeah.
The point I'm trying to make is this is a guy that came in looking to end the investigations of Trump and protects Trump. And so this is the same person who at the end of his administration said, pretty much this is all nonsense. So this is not a rhino. This is not somebody who had behaved disloyally to Trump in any respect whatsoever. So I mean that's the reason why I wanted to give this type of background, so that people would not just say, "Oh, Barr was just a rhino," and he was just
no. But remember, Ben, the one item I think that we can add is the Flynn, dismissing the Flynn prosecution.
Oh yes,
where Barr interceded and said, "Okay, well, we're going to dismiss the case." This is somebody who had already pled guilty, right? He said, "Okay, now you can withdraw your guilty plea." So William Barr was no code pink, or Antifa, disloyal to Mr. Trump, and that's the level. And think of Mike Pence himself. He's a loyalist to the nth degree, and Mike Pence himself said, "I can't do your bidding. I have an obligation under the Constitution. These state certified votes are valid. I'm counting them." And he did his duty. And you're telling me Mike Pence, who was chosen by Mr. Trump and showed loyalty for 4 years, is trying to subvert the Republican Party and Donald Trump? And the whole idea is absurd on its face. And that's, which gives, extra credence, I believe, to the seriousness of the charges against Mr. Trump. And I believe, Jeffrey, that if these cases went to trial, virtually every witness who incriminated Trump would be a member of the Republican Party, many of them appointed by Trump himself. So it's not a Democrat organized, witch hunt for sure.
And that's the point Smith made when he testified.
Yeah,
that a lot of the evidence he got were from Republicans and MAGA Republicans.
Yeah.
Not people that would be considered, but MAGA would consider rhinos. Well, maybe MAGA would reclassify them if they heard people testified against Trump. They'd have a different opinion of them, but but their reputation is as these are Trump supporters, not Trump loyalists, not the anti-Trumpers. In concluding this this intellectual feast, why should or should not, is the book worth reading? And if so, what do you think? Why, if you think somebody should read it, why do you think somebody should read the book? What do you think they'll get out of reading?
Okay, again, I don't, listen, I don't want to criticize authors for writing a book that they didn't intend to write. I think the book is clearly worth reading if you don't have a strong background of how justice works and you're dealing with human beings, that the law is not an algorithm and you punch in numbers and outcomes, yes or no, or guilty or not guilty. So it gives a little bit of color on that score for sure. And I do think it underscores, I believe, the volume of evidence against Mr. Trump, that if these cases went to trial, would likely, in my judgment, result in guilty verdicts, even if you had all Republicans sitting in the jury pool. I'd say where it is, again, I'm maybe criticizing where I shouldn't. It's deficient, is I don't believe that the authors quite understand the challenges of prosecutorial discretion and the fact that this wasn't sui generis, that other presidents have done it, certainly not on the scale. But how is this? I would like them to address how is this different in abuse than Robert Kennedy's Jimmy Hoffa squad? Is that different than Trump or other people just going after their enemies? And if so, how? And moreover, they don't have any role at all in their discussion of Congress. A little bit with regard to the committee that was appointed by Pelosi for the events on January 6th, but very little on how are you going to remedy this and prevent it from happening in the future. Again, they didn't set out to do that, but I think it would be helpful if they offered it. It ends rather abruptly and said, okay, Trump's got a get out of jail free card, but not so much, well, how do we move forward and try to prevent this from happening again? But again, if they're Washington Post reporters, and I'm not going to criticize them for writing a book that they didn't intend to write.
Do you think it was a fair book?
Yes, I do think it's a fair book, and presenting what I consider rational arguments. So I don't think it went out of its way to try to paint evidence that was less incriminating than it might otherwise have been. In fact, in my judgment, the greatest omission that I noticed in their chronicle was the confrontation, very vivid, that the vice president testified to on the morning of January 6th, when Mr. Trump confronted him and said, Mike, you got to choose between me and the Constitution. And I mean, that is dramatic. And I mean, it shows that Trump knew that what he was asking Pence to do was unconstitutional. There wasn't any, I got legal advice that I'm not sure about X, Y, Z. And that's not in the played up in as I would have done, because I think that's smoking gun.
No, I think, and then after I make the statement, I'll give you the last word. But I think, you should not expect anyone who doesn't care about whether something's true or not true to also care about whether something's right or wrong.
Yeah.
So, how would you like to conclude this conversation, Bruce?
No, I think it's important that people, like these reporters, provide, in some sense, it's important to read because we didn't have the trials that we probably should have had or we all needed in order to have a more verified narrative of what happened on January 6th in the aftermath. But I think that it shows also we need books written about, okay, how to prevent this from happening in the future. And I think it's not necessarily for journalists to write, but it's for teachers and public intellectuals to say, we got to sit back and say this is not a people phenomenon. It's an institutional breakdown, which is what we have.
Well, thank you very much, Bruce, and have a great day. And I'm looking forward to you choosing the next book and us scheduling the next one of these.
Wonderful. And I really appreciate the audience, that tolerates this. I know a lot of it is not as exciting as TikTok or electrifying as, maybe a Taylor Swift concert. But I think both Jeffrey and I hope it's got more sustenance to it. And it doesn't depreciate overnight. Okay. Okay.
Bye.
Thanks. Okay. Bye-bye.